So for any of you that fast forwarded it to the top 5 quick round legal tips, here they are. Quick tip number 1. Keep it simple. This is for language, in agreements, and in anything that you write anywhere ever. Using, to is better than heretofore, and for is better than wherefore thou, or whatever. Take out any complicated language. It just makes it, if you take it to court, the language is much harder to actually litigate. And it's harder as a human to be simple and clear than to use big words and to make things complicated. So know that keeping things simple, it will help you at every stage of your life. And if you get into a dispute, your answer should be simple. If you're ever talking to someone, do not give a lot of explanation. Keep everything simple. That is the number 1 tip there. It sounds easy. It is simple, but it is not easy. Number 2, don't ever delete evidence. The courts see that as a much, much worse crime than whatever the papers, text, or emails say. And lawyers are specifically trained in ways to keep that information out of the court. So just make sure, do not delete it, do not hide it, make sure your attorneys are in the know. This is the same thing for taxes. So not filing your taxes is much, much worse than not paying your taxes. So always, if you're like, oh, I can't file them because I can't pay them, don't do that. File it, pay later. Your penalties and interest will be a lot less than if you don't file and don't pay. See Glenda for more information on this. Number 3, if you ever have an attorney, tell them the full truth and nothing but the truth. Because attorneys really don't look at situations personally or judgmentally. The more facts they have, the better they can protect you and try to fit you in corner cases of the law that have happened and position your case. So give them all the facts. Number 4, in any agreement, there are only a few clauses that are truly important. One is the termination clause or the breach clause. For example, like for an NDA, if you sign a non-disclosure agreement, most non-disclosure agreements only have what's called injunctive relief, that they can take you to court and get you to stop doing something. That's really not that great because it costs $10,000, $20,000 to go to court, only for them to get you to stop doing something, right? Versus our agreements have actual cash penalties that if you disclose information, it's $20,000 to $50,000 per violation that people have to pay. At the end of the day, it always comes down to money. So check and see what those termination clauses are. The second section of the agreements to look for are the jurisdiction and venue clauses. This means where you would have to arbitrate a dispute or file a case. So a lot of Google's are probably in California, or a lot of companies have them in Delaware because they're very, very business friendly. So if there's a chance you think you may have to litigate related to an agreement, check where that venue clause is. Finally, this is a Trisha Cole original. It is the attorney's fees provision. I'm a big advocate that all parties should bear their own attorney's fees in all matters. Now, there are some statutes that give you your attorney's fees back if you win, and that can still be in effect. But the truth is, over and over, I saw people that went way past the point that something should have been resolved because they had these attorney's fees provisions in their agreements, years and years past when they should have been resolved. And the truth is, when it got to the judge and was resolved, the court will only award a small portion of those attorney's fees because at that point they're outrageous. So you'll still be on the hook for paying the attorneys the balance. They're not going to walk away with whatever they were awarded. And the only person that wins from those protracted suits is the attorneys. So that is one of the most tricky ones that I run into. So make sure to take a look at that. That clause. And if you have any other questions, let me know. I love talking about those agreements. But so finally, number 5, for life and for law, if you found yourself in a situation where you're doing something on principle or for the principle of it, have someone physically pull you away and get you to stop whatever you're doing. This is a very bad decision to proceed at this point, because you will never get to a place that you feel fully vindicated. And you know who makes the most money off these principal fights? Attorneys. When I would ever hear a client say this, and still to this day, if I hear people say it, I run away if it's on principle, because you cannot see clearly and you need help. I had a few times where I had to talk people off the ledge. One example was a company that we had that was a big technology company that was going after someone for a $5,000 breach. And, you know, to file a complaint against this person is like, you know, $10,000 to $20,000. So we had to go through, like, as a CEO of this company, is this the best use of your time for your business from a fiduciary perspective when you owe this responsibility to the company? But from inside, when you're inside and it's a principal thing, it's really hard to do. But it's just like they say about hate, right? Hate is like swallowing poison and expecting someone else to die. No matter how much you get back, your principal will never fully be vindicated. And while you are venting to your attorney and they're doing all this stuff for you, the bills keep coming in every 6-minute increments, which is how most attorneys bill time. And you will never actually get to the point of feeling happy with the resolution, because courts often lean towards results that are beneficial towards both parties. So get a mutually disagreeable settlement as soon as possible and move on. So thank you guys for going through some law stuff today, and I will see you again probably next month. Thanks. Bye.